Hi, and welcome back. Attorney Steve Vondran. Boy, what a week in the BitTorrent trenches. So we are talking in this video about a basically an order that was granted by a judge in a Maryland case. And I misspoke yesterday in one of my videos when I said it was a Central District of California case. This was actually an order that came from a Maryland case, Judge Marvin Garbus. So it was really interesting because it talks about granting a plaintiff in a federal court case, one of these illegal download cases, these pornography cases, file sharing, it grants a plaintiff a right to conduct a 1-hour deposition. So this is kind of new. I think it's kind of interesting. I'm not sure if I like it or I don't like it as of yet, but it's kind of interesting. So I wanted to talk about it for those of you who may be involved in a torrent lawsuit or get a ISP subpoena claiming that you're a copyright infringer. So here it is. This is the actual order from the court. You can see the case here if you want to look it up. It's a strike 3 holdings case, and we are seeing a lot of filings in California in regards to strike 3 holdings. We're seeing them in the Central District of California, Northern District in the Bay Area, and the Central District is, Los Angeles, Orange County, Riverside area. So a lot of lawsuits are being filed. Malibu Media is not stopping. So let's go over this order. I think it's pretty interesting and maybe something courts should be doing in all cases. But let's go through this. Strike 3 has filed the instant motion requesting permission to initiate discovery to identify the account subscriber. So as you know, what happens is whoever's a subscriber on the account ends up getting an ISP notice saying, we think that you're infringing, and the ISP is being demanded to turn over that information, the name and address of the subscriber. Now, the subscriber may or may not be the actual infringer. It may not even be anyone in the household. It could be an unsecured wireless network. It could be a stayover guest. It could be anything. So this case is another one of those cases. And usually, as it notes here, federal rules of civil procedure, which govern in federal cases, preclude a party from seeking discovery from any source before the parties have conferred as required by Rule 26. That's a fancy way to say normally you're not allowed in a federal court to engage in discovery once a lawsuit is filed. Now, in most state courts, for example, in California, Arizona, 2 states that I'm licensed to practice in, we file a lawsuit and the party answers, we can get going. But in federal court, you have to actually have the meet and confer and the scheduling conference and things like that. So that's what this case is about. Let's go down here. Now, I'm just going to start over here if I can, but as you can see here, strike 3 may obtain, this was an order from the judge, may obtain from the clerk a subpoena to be served on the ISP. So we know that that's pretty typical in all cases. Under federal rules of civil procedure, section 45, you can serve subpoenas. So the court's saying we're fine with that. Go ahead with the early discovery. After having been served with a subpoena, the ISP will delay producing to strike 3 the subpoenaed information until it has first provided the Doe subscriber. When I say Doe, people are sued as John Doe. Must first provide the Doe subscriber with notice that the suit has been filed, naming the Doe subscriber as the one that allegedly downloaded the copyright-protected work. So there's a notice, a copy of the subpoena is served, and the copy of the subpoena basically tells you if you want to file a motion to quash or you have some other grounds to stop the transfer of the information from the ISP to the plaintiff, then you got to do it in a timely manner. So that's what that's about, and that's pretty typical. Here we have in purple, the Doe subscriber may move to quash the subpoena anonymously. And so if you want to file the motion to quash, in the past, some courts have said, you can't file a motion anonymously. We have to know who you are and what's going on. This court order is saying, yes, you can do it anonymously. You provide the current address to the clerk of the court, the name and the address. And so now we're seeing that, this is being provided to the clerk. The clerk, you can file the motion, and that information will not be released to the plaintiff. And that's what it mentions here. So you can read that if you like. Coming over here, if I can, up to the pink here, if the Doe subscriber fails to file a motion to quash or for other appropriate relief within 30 days, the ISP shall provide to strike 3 the information requested in the subpoena within 14 days. So you either make a move to stop the subpoena, or within 14 days that information is going to be sent from your ISP, Comcast, Verizon, AT&T, and that's going to be sent over to the plaintiff. Okay, so here we say in green, pursuant to Rule 45C, strike 3. And I highlighted this because just so people know, sometimes they're settling these cases, and my clients are like, well, why do they want this? Why do they want so much? Here's one of the things: pursuant to Rule 45C, strike 3 has to reimburse the ISP for its reasonable costs and fees. So the ISP, has to take their time. There's somebody assigned to that. They have to get your information. They have to ship it out. So whatever that's worth. I mean, maybe it's $100, maybe it's a couple hundred, But again, their strike 3 is going to want to be reimbursed in the course of a settlement discussion. All right, on receipt of the information, the ISP, this is in yellow, the ISP must mark it as highly confidential. And essentially, I'll let you read that, but anybody who gets the information, it has to be bound by a confidentiality agreement. And that's what it says down here. So now let's get to the juice. This is what this video was about. If strike 3, this is down here in green, if strike 3 determines that the information they received is insufficient to support the filing of an amended complaint, because remember, you can't just go sue willy-nilly anybody that you want. Just to say that that's the case doesn't mean that that's always what happens. Some of these companies, they don't care. They're just dying to get your name out there and get this case going, and they don't care. But what this says is if strike 3 determines that the information received pursuant to the subpoena is insufficient, in other words, a plaintiff lawyer says, look, it's not them, it's somebody else, or it's, you need, usually the response is, yeah, right. I'll take the deposition of your client. I said, well, that's part of the discovery process if you want to do that. And in a lot of cases where my client didn't do it, I'd say, we're willing to even show the forensics on our computer. If you want to look at the computer, that's fine. Let's go. What are you waiting for? But don't name the wrong person, or you may be looking at a malicious prosecution type of thing once I win the case. So that's something that comes up. So that's what this order actually talks about that I found interesting. If strike 3 determines the information received pursuant to the subpoena is insufficient to support the filing of a good faith amended complaint, it may serve a subpoena commanding the subscriber, because now they know who the subscriber is, to appear and attend at a deposition to answer questions regarding whether the subscriber was responsible for downloading the copyrighted work alleged in the original complaint. So that means they can bring you in, they can go eyeball to eyeball, they can have you bring in your computer, they can see if they believe you. In some cases they may say, you know what, this person's totally believable, and maybe it was an accident, maybe, a neighbor did this, maybe it was somebody. There's all kinds of scenarios. Somebody in the military's, stopped in for the weekend and they're out. You have guests coming over for a party, VPNs that look to access unsecured IPs. There's lots of different scenarios. So this says that the plaintiff, strike 3, has the power to issue a subpoena. Now, Section B here is very important. Pursuant to Rule 26B2C, the deposition permitted pursuant to paragraph 3A, that's this one, of this order shall not last more than 1 hour in duration. So there's a time limit. So they can get you in, swear you in, they can probably ask you a few background questions. And believe me, in a deposition, an hour goes very, very fast. In California, we have a 7-hour deposition for our state court cases, and, that's sufficient time to ask a lot of questions and really get to feel out somebody's credibility. But this gives you 1 hour. So they got to get in, they got to ask some quick background questions, they got to take your deposition, they got to try to get to the heart of the matter and decide if they think you did it or not, okay? So that's the basics I wanted to show you about this video. Just know it's out there. I hope more states, actually, more judges are willing to grant that kind of order, because I think, there are innocent people in our defense of these cases, but, unfortunately, the plaintiff lawyers, they've never seen the subscriber, they don't know them, they're not talking to them. In fact, this order this order, I didn't read that part, but there's part of this order that actually talked about not being able to contact an unrepresented DOE defendant. So, even, extra protections. So the plaintiffs are probably going to take advantage of this. They're, it costs money to do a depo. You're talking about $1,000, probably about $1,000 to do a depo, attorney time. So it may be in rare cases that it's used, but it is a tool and it might be used. And the final thing that I won't go to, we'll leave you at this, but the final thing is that, you can raise defenses. The order talked about you can raise the Fifth Amendment defense, work product, attorney-client privilege. You can raise your defenses in the deposition. So that's an overview of something new that I found that I think is pretty interesting. So, something to think about. And if you need help with a torrent case, we have a great track record helping clients get these cases resolved. You can find out more information at attorneysteve.com. Have a great weekend. I got to get back to work. These plaintiffs won't stop filing, so we won't stop working defending our clients. Thanks a lot. Have a great week.